Lords, can I go directly to the question put by my Lord, Lord Justice Snowden at the conclusion of yesterday's proceedings, and seek to answer it by at the same time also explaining to your Lordships why, in our submission, the approach that the judge took to this was correct, because they're parts of the same submission. The core answer to my Lord's question is this. There is a distinction to be made, and it is sometimes a subtle distinction on the facts, between a service that enables an action to take place and a service that is designed to attract that custom to it. We don't dispute, nor could, that the relevant web facilities enable the transactions to take place. And to some extent, they make it easy in this sense, that they enable shipping to take place, they enable payment in a particular currency, but that is a different matter and a different question in our respectful submission from the core question that the judge needed to consider, which was whether or not the relevant goods were targeted at the United Kingdom. And can I show, my Lords, how the judge reached that conclusion, and in so doing then explain why, where he drew the line and how he drew the line?
You certainly can, Mr. Alexander, but could you just tell me whether you agree with Mr. Edinburgh's caution about the use of the word targeting, which seems to imply a subjective element of deliberately doing something in order to achieve a result, as opposed to the objective test that is really required here, with subjective elements being relevant in particular ways. Is it better to look at use in relation to an offer for sale or advertising?
My Lord, yes. There is always a risk in putting a gloss onto statutory wording where one's concerned with use in a given jurisdiction. The only reason for hesitation in not embracing the caution to the fullest extent is that that is the way in which the matter has been dealt with in the authorities repeatedly in order to capture the concept of targeting or directing. Where in our submission we agree with the claimants is that the test is objective, but evidence relating to subjective intent is potentially relevant. That's no different to many other areas of trademark law in relation to, for example, causing confusion, where the test is an objective one of whether or not confusion will be caused as a result of signs being unduly similar, but an intention to cause confusion may be relevant to whether or not the statutory test is satisfied. To that extent, we agree with the caution, but the caution doesn't go so far as to say that all relevant factors should not be taken into consideration. I'm sorry, I put that rather poorly. In our respectful submission, in evaluating the objective question, the court is entitled to take all relevant factors into consideration in reaching its conclusion as to whether the relevant goods and the mark are targeted or directed at the United Kingdom.
Right, well, that's very clear. Thank you very much. So we're going to go and look at the judgment.
So can I just invite my Lords to go to the judgment and take it up at paragraph 161. And if I could just briefly, without labouring this, identify the points that the judge took into account and explain briefly why we submit that he was right to take them into account and right in the overall evaluation that he reached. First point in relation to 161 is that the background to evaluating whether or not there is an attempt to attract sales as opposed to merely enable them is one where the mere visibility of a site, and one might say the mere availability of a site, is not regarded as sufficient to satisfy that requirement. And the judge rightly took that into account. And the reason that it matters in a case of this kind is because what might be called the baseline legitimate activity is one of passive availability. That is, in our respectful submission, not something that attracts liability on the basis of targeting. And so the question that the court needs to address is whether, given that that baseline is legitimate, that people can go to foreign websites and, as it were, visit them for themselves, whether there is something that goes beyond that availability in the relevant website that makes it such as to be attracting rather than simply enabling.
That's precisely why the whole debate about Amazon.com as a website is completely irrelevant. Because nobody could possibly suggest, and the claimants don't suggest, that a consumer visiting that website results in any infringing activity at all. Plainly not. Because, for starters, until you do a search for a product, there is no use of the sign at all by anybody.
My lord, yes. There is a slight wrinkle on that argument, which is that, at least as we understand the argument put below, what was said by the claimants was that one needed to look at the concept of Amazon.com targeting the United Kingdom as a whole, rather than looking at the matter on the basis of individual products. Now, their argument may have shifted to some degree on that.
I'm surprised if that argument was put, but if it was, it's been clearly disavowed in this court.
Indeed, and in any event, that's the reason why that's one of the starting points.
So the inquiry starts with the search for the relevant sign.
Indeed.
And of course, you take into account context, which is that the website is the Amazon.com website and not the .co.uk website. But you start with the search and the results of the search, do you not?
Indeed, but there is a question mark as to what search one is conducting, because as the judge found below, if one does a search for Amazon as such, so what might be called the name of the shop in very broad terms, the first Google entry that comes up is amazon.co.uk. It's not amazon.com. That's, I think, the third entry down on the judge's findings. Now, if one is, on the other hand, searching specifically for the relevant goods, matters may be different. I'm not sure that's dealt with specifically in the evidence. I'll check on in relation to that. But in our respectful submission, one of the factors that the court is entitled to take into account is what the overall search, if I may put it like that, for the shop as a whole yields and is intended to yield. So my lord is of course right that the context must be taken into account, but in our submission it is right to take the whole context into account.
Well, you'd got to 161.
Yes.
You said mere accessibility of a website cannot constitute targeting.
Yes.
I think we're agreed about that.
But we are, and the only reason for making that submission, my lord, is the point about baseline, because what one is doing is making a relatively fine distinction from a position where the law doesn't say, well, you can't be accessible at all to the United Kingdom, because that would constitute targeting.
No, well, let's
So
keep going then with
let me keep going with that. 162, the trial judge took account of the fact that the UK and each other EU country and others have their own targeted Amazon website. Now that again...
It appears to have been put below as if that was determinative. I assume you would accept that can't be determinative.
No, I am not suggesting that any of these factors taken in isolation is determinative. My submission is that the judge took account of a range of factors, made a multifactorial assessment, as he was bound to do by the approaches in Merck and Argos, and reached a conclusion that was a reasonable one. Now, that is, in my respectful submission, a relevant factor to take into account. Whether or not something is targeted at a particular jurisdiction, one is entitled to take into account the fact that there is something that is specifically targeted at that jurisdiction, which is intended for those in that jurisdiction.
And perhaps more importantly, that the average consumer knows that.
Yes, that the average consumer knows that. Third, and going on to paragraph 163, the judge took into account, again as we say he was entitled to, the evidence that Amazon preferred its customers to shop on their local Amazon website and seek to persuade them to go back to the website if they have gone to amazon.com.
Is that relevant, bearing in mind that the average consumer has no idea what Amazon prefers?
Well, we would respectfully submit that it is, and this goes to the question of what factors the court is properly entitled to take into account, whether they are only factors known to the average consumer, or whether they are factors that are in fact the case, but not necessarily known to the average consumer. For example, the next factor that I'm coming on to in 164, the actual volume of traffic. Now, an average... I'm sorry, my lord wanted to interject.
Sorry, you finish.
My lord, the judge below took account of the fact that the traffic to Amazon.com from the United Kingdom was very limited. And in our submission, that is a factor that it is appropriate to take into account. Now, if my lords hold that in evaluating...
It was limited. I mean, in fact, you hadn't put in any evidence. I mean, quite why not is a mystery, because it would have been very easy to put in the relevant statistics. You didn't do it. One might ask why not. So he makes an inference in the absence of any evidence that the volume of traffic would be, quotes, very small by comparison with the numbers from the US.
Yes, and in our respectful submission, that's an inference that he was entitled to make in the absence of specific evidence relating to that, and he provides an explanation.
But I mean, you could have put in evidence showing that it was 0.00001%. You didn't.
Actually, I think we did in relation to the products in question, and the judge has actually specifically referred to that in paragraph 78 of the decision. If my lord would just be good enough to go back to that.
So the percentage of active users is between 0.6 and 0.8%.
Yes.
So do I understand your submission to be that when the judge says at 164 very small, that's what he has in mind? 0.6 to 0.8%, or rounding up 1%?
I will need to have that checked, but I assume that that is what the judge had in mind, because he was drawing an inference based on the other evidence. And this was the evidence relating to specific active users.
Right, but the number of visitors from the US exceeded 100 million. So if we take the middle figure, 0.7%, 0.7% of 100 million is a lot.
Well, my lord, that's the website taken as a whole. the evidence in relation to this was...
You just referred me to the data on active users for BHPC products.
Yes, indeed. The data in relation to the website as a whole was the number of monthly unique visitors from the US, which exceeded 100 million. That's not 100 million people looking at BHPC products.
No, it may not be, but the Claimants products are listed and available to those nearly 1% of 100 million, which is a million. So a million UK, EU consumers access the American website and can access the use of the sign there.
In principle, they may be able to access it, but then one needs to take
Not
in...
may be able to, Mr. Alexander, they can. I mean, it takes half a dozen clicks to get to...
Yeah, yes, but my lords also may want to bear in mind the very modest volumes of sales that resulted over the full period as a result of that, which is the further point. But my lords, just staying on this point just for the time being, because this is an analytically important point for my lords, is it right to take into account at all the actual number of potential and actual sales on a website on the footing that that number would not be known to the notional average consumer?
And you just submitted 2 minutes ago that it was.
Yes, and I do make that submission, that it is reasonable to do that. But
so you can't have it both ways, can you? You can't, on the one hand, point to the large number of monthly unique visitors from the US of 100 million, but then seek to discount the fact that when you look at the products in question, we've got 0.6 to 0.8% active users coming from the UK or the EU.
I'm not seeking to discount it in the sense of saying that that is irrelevant. My submission to my lords is that it is relevant and it is very small, and the judge was entitled to take into account the fact that it was in fact very small in relation to the products, in question.
It's a small percentage in the sense that it's less than 1%, for sure, but it's less than 1% of a very large number.
Well, no, that's only if one assumes that 100 million of those US users are actually looking for BHPC products, because what one's doing is looking at that there are two different things here.
Look, what he said, I mean, let's deal with the judge's findings. They're not going to appeal. The last sentence of 164, as I concluded above, I believe the volume of traffic generally would probably mirror the volume specifically viewing BHPC product listings and would be very small by comparison with the numbers from the US.
Yes.
So he seems to be saying 0.7% is a reasonable estimate, and it's applicable both to the general traffic and to the BHPC traffic. So it's 0.7% of 100 million general, 0.7% of a much lesser figure for BHPC.
Yes, that's the reference to the general traffic, as my lord has pointed out. In any event, in my submission, this is a matter that the judge was entitled to take into account in determining whether or not of the options of .com and .co.uk, .com should probably be treated as targeting the
yes,
United.
But it's not a determinative factor.
It's not a determinative factor, and
so we need to go on and see what
we need to go
did
on.
find.
Then the factors that Mr. Edinburgh.
I was going to intervene when you were on 163, and then we went to 164. Yes. Can we just go back to 163 for a moment?
Yes.
The evidence that the judge there refers to, which is that Amazon seeks to persuade customers to go back to the local Amazon website if they've gone to Amazon.com. Is that anything more than the little strip that says we saw on the page, which says that you can click here to go to Amazon.co.uk?
My lord, I'm not able to give an instant answer to that, not having not having the full nature of Mr. Tripathi's evidence in mind.
And then to go on, he says that UK customers who choose to stay on Amazon.com and to shop from there are making a conscious decision to do so, despite knowing that it would be simpler, quicker, and most likely far cheaper in respect of shipping costs and import duties to shop on Amazon. Well, obviously, if you're shopping on Amazon.co.uk, you're not going to pay import duties.
Yes.
You may obviously pay lower shipping costs. That's probably true. But there are many other reasons we explored yesterday why people might prefer to shop on Amazon US.
Indeed. And I can't shrink from the fact that people may prefer to shop on Amazon US.
And to those people, the goods are offered for sale and delivery. And there is no, to look at the last sentence, 163, there is no indication until you try to check out now that the goods are the Beverly Hills Polo Club goods are not available for shipment to the UK.
Yes, but
quite the reverse. You're promised that they can be shipped to the UK, and you're asked to select.
Let me come back to that, but I don't think you are. Post the restrictions, it doesn't say that you can ship to the UK. I mean, I think my lord is looking at the matter pre-restrictions. Is that correct?
I thought you were only told that you couldn't get them shipped to the UK when you try and check out. So up till then, you get the little thing in the, you can ship to it can be delivered to the UK. You go all the way through, and I understood that you only get stopped right at the very end of the process.
I'll have that checked on the evidence, but my understanding is that there isn't something that indicates that they ship to the UK on the earlier, so the equivalent of 116, once the restrictions were in place.
Isn't that correct?
I'll check that, but
I've misunderstood. I don't know whether I'm.
we can check that in the evidence, and I'll check that with my learned friends so that you've got the full position in relation to that. But just to an immediate response and to foreshadow the points to which I'm coming, the fact that if one is on the Amazon.com website, the shipping costs are very significant and the import duty costs are very significant, are also matters which, in our submission, the judge was entitled to take account of in determining whether or not the goods on that site were directed to, targeted at the United Kingdom.
Okay, you say very significant. I mean, the examples we were given, I mean, I'm just looking at them. I mean, the judge later in the judgment describes them, I think, as exorbitant or something.
Yes.
But the actual examples we were given don't show massive shipping or import duties. I mean, admittedly, we're looking at the, for example, a printed T-shirt, but
yes, that may be. Well, again, I don't want to give evidence here or mislead you. That may be because of the specific costs in relation to those specific articles, which are the exemplars. But the judge found, as a matter of fact, that the shipping and associated costs with these products were very significant.
Well, I mean, the one I'm looking at, which is at page 55 on the electronic version, is about 30%.
Yes.
Well, 30% is very significant to some and not very significant to others when it's $8.
My lord is right, and one needs to look at this in my respectful submission in a comparative way as well. Say, well, look, all these.
I mean,
costs,
it would be just moving on. It would be useful for me to have your analysis of going through, continuing through the judgment.
Yes, that's what I was going to do, just
to see how the judge dealt with it.
Yes.
And for you to explain why what he did was right.
Yes.
In contrast to Mr. Edinburgh's submissions, that what he did was, if I can put it this way, bang wrong.
Yes. Well, let me then pick it up at 165.
Yes, good.
We don't say that the judge was wrong to take these factors into account as well. He was entitled to take those factors into account as part of the overall analysis. But he was equally entitled not to find that those factors were themselves determinative of whether or not the relevant goods were targeted or directed at the United Kingdom. My learned friend's submission is that he ought to have found, on the basis of the matters in paragraphs 1 to 8, that because of the indications on the web pages, essentially, there was thereby targeting at the United Kingdom, and your lordships will have noted that they're all factors that are related to the presence or otherwise of language on the particular web pages in question. So what they are looking at in terms of the context of use, context of use, is just the matters on the web pages. And my lords were taken through that yesterday by reference to pages 116 and 123 and others of the supplementary bundle. And in our respectful submission, while those are factors, those are not the only factors. And so if I can then come on to the other factors that the judge took account of in paragraphs 166 to 170.
So you're not going to go back to the core documentation that Mr. Edinburgh took and contest his construction or interpretation of the words on the page?
Well,
you accept that the judge reflected them in paragraph 165, and Mr. Edinburgh says, well, these are what they are, and you don't say they're different.
I don't say that the way in which the judge reflected them in 165 was incorrect.
No.
To the contrary,
No.
they were correct, and he took into account those factors. I don't really detect that Mr. Edinburgh says that the way in which they were reflected in that paragraph was itself incorrect, or that the judge made inappropriate observations in relation.
But you see,
in relation to them.
You need to go then to 168.
Yes.
Where he starts to explain his reasoning. I'm sure that's where you are going.
Yes, that's just where I am going next. But before I do that, can I meet a couple of other points head on, which are in 166 and 167?
Yes.
Because the claimants say that the average consumer would consider, because of the factors in 166, that Amazon.com was targeting them, and the adverts and listings that they go on to select are targeted at them. And he records that argument, and it's the same argument that was put to your lordships. And then there was the further point in relation to 167, which is the other relevant factors aside from the average consumer's perception. And then we come on to the other factors that the judge...
So was the judge wrong in 167? I mean, to say that, for example, Amazon structures its offering, for example, with estimated import duties, and the guarantees in relation to those, to make it entirely straightforward and easy for people to buy goods on Amazon.com if they are based in the UK?
No, we don't say that it is not easy for people to buy goods on Amazon.com in the UK to that extent. But it's no different from.
Sorry, so you accept it is easy for people to buy goods on Amazon.com from the UK?
It's not made difficult for them to do that, and there are certain aspects of the business which make it easy. But that's no different from saying, let's leave Amazon aside for the time being. Let's suppose one has a crafts shop in upstate New York. You go to their website, and they say on their website, we will deal with shipping the product to you, to the UK, and don't worry about
offer to pay their estimated
handling.
import duties.
Well, but one has to be a little bit careful about that, because the estimated import duties is not a charitable offer. What it is saying is, look, these are the import duties that are maybe levied when the goods are imported. We can't absolutely guarantee that those will be the import duties.
But you do,
Yeah.
because you pay the excess.
Oh, indeed, but that's because Amazon says, okay, well, look, if we have estimated what the relevant import duties are, then we're not going to go back to the consumer and say you should be paying the excess if it turns out that the import duties are slightly bigger than they were estimated to be. But in my submission, that's no different from a undertaking saying, well, we will deliver the goods to, for example, a local store of your choice where you can collect them or whatever. It is enabling that transaction to take place, but it's not specifically enabling it with respect to the United Kingdom in our submission.
Right. I mean, I think we need to.
Let's move on, if I may.
Okay.
On paragraph 168.
It's enabling the transaction to take place, but not specifically enabling it with respect to the United Kingdom.
So the counter-argument, the other points are that this is evidence that Amazon strives to provide an easy customer experience, and we don't deny that is what we intend to do. But those are matters that actually the customer is only going to get to once the customer has already decided that they want to purchase those goods on Amazon.com. This is not something which a customer would necessarily know even in advance. Once they've decided that they want to go to purchase goods of this kind through that particular source, then they discover that Amazon strives to provide an easy customer experience. But that is a different point from whether or not Amazon.com is in advance encouraging customers to purchase their goods through Amazon.com as opposed to through Amazon.co.uk.
But why is that the relevant question? I mean, let's test this by reference to an actual example. So let's take supplementary bundle, tab 1D, page 123 in the bundle. By this stage in the process, the customer has put the order into their cart and they're about to place the order. And we see that the shipping address is Holborn Viaduct in the United Kingdom. The billing address is London in the United Kingdom. The customer is invited to place his order in GBP. There is shipping and handling fees as well as the price. And when it says select payment currency, it's GBP, and there's the exchange rate given. Now, how on earth is this not targeted exclusively at the UK?
Well, once someone has decided to make a purchase from a foreign website and has put that in motion, the activity in getting the goods to the United Kingdom is going to be, to that extent, targeted at the United Kingdom, inevitably to that extent, because they are going to be...
Are you therefore accepting that this offer for sale is plainly targeted at the UK?
No, I don't accept that. And the reason I don't is, let's take a slightly different context, because one has to test this by reference not just to what Amazon does,
No,
but...
I'm asking about this specific one.
No, I don't accept that it is targeted at the UK in virtue of the matters that my Lord has identified. In any transaction which involves the sale of goods to the UK, there will need to be identified a shipping address in the United Kingdom. There will need to be provided a currency. In this case, there are alternative currencies provided. There are pounds provided.
This one is pounds.
Yes, but you can see that underneath that it says selected payment currency GBP US dollars. The GBP box has been ticked, and obviously then if you tick the US GBP box, then what comes up is an exchange rate to show that there is an exchange for US dollars.
Mr. Alexander, the problem I have is that in paragraph 169, the judge says that the average consumer is not stupid and knows that the .com website is targeted at US people and not him. And that may well be true in the use of the traditional meaning of the word targeted. But when you change the question to whether you're using the sign in relation to the offer that my Lord has drawn attention to at page 124, then it's perfectly obvious that the sign is being used in relation to an offer for sale, and any average consumer would know that. So it's the use of the word targeted which creates this balance between whether or not it's really for you, or whether or not you have to go out of your way to go there. But that is not the correct test of whether it is so-called targeted under trademark law, is it?
Well, we would respectfully submit it is, and I'll perhaps try and make the argument a little bit clearer, and take an example that is not this one. I'm not trying to dodge answering my Lord's questions in relation to this, but let's take the example of the small retailer in, give an example of upstate New York. A person from the United Kingdom goes onto their website, perhaps they've visited them on a holiday. They see that the retailer will ship goods around the world. They say, can I please have whatever it is, not necessarily even through an e-commerce platform of this kind, but there's an exchange of emails in relation to that. Will you ship it to me? The retailer says, please give me your address in London, to which I should send it. Would you like to pay in pounds, or would you like to pay in dollars? Because either is fine by me, or euros. In those circumstances, what one might say, to use the language of some of the cases which I use with some hesitation, the retailer is not, as it were, pushing the product into the United Kingdom. What's happening is that the customer is saying, please supply it to me from abroad. And in our respectful submission, this 123 is no different from that.
But the example you've given is pretty close to the facts involved in the Walton case, where I held that sales were targeted.
Your Lordship did hold that sales, well, your Lordship held that sales were targeted. Your Lordship held that advertisements and offers for sale
It's a generality.
were not in that case.
So to translate it into the circumstance of the present case, in effect I said amazon.co.uk and the general listings of BHPC products on that not targeted the UK. But as soon as you get down to the level of 1, 2, 3, yes you are.
Well, my lord, the argument in a sense is this. If my lord's of the view that once one gets to a sale transaction of any kind, because the sale transaction necessarily involves identification of an address in the United Kingdom, potentially an option to pay in United Kingdom currency, a scheme possibly to deal with import and other duties, that automatically means that sale is undertaken in a way that targets the United Kingdom.
But why
then,
isn't it?
Well, we would respectfully submit that it's not targeting the United Kingdom because it's a passive sale. My lord may recall the old European jurisprudence concerning passive and active sales into particular territories.
Right. And I adopted the terminology in Wharton of pulled pushing.
Indeed.
This is pulled pushing. And once you get to pulled pushing, you're over the line.
Well, my lord, there's probably no more that I can say in relation to this particular document. In our submission, that is, the line should not be drawn in precisely that way. Where there is a availability of a website, and people in this country pull, to use that term, there is, in some senses, inevitably pushing. And the reason that there is inevitably pushing is because otherwise the products don't get delivered to the United Kingdom at all. If that is sufficient to be use in the United Kingdom, that would mean that every sale in the United Kingdom would, the question would answer itself in relation to the sale. You might have a multifactorial assessment in relation to advertisements and offers for sale, but in relation to sales in the United Kingdom, because of the points that my lord has put to me, you're always over the line in relation to that. And there is nothing that a trader could possibly do in a foreign country, even if they said...
What's wrong with a result that says that you can't sell into the UK when there's a UK trademark that blocks you?
Well, you might say that what's wrong with the result that says you can't advertise or offer for sale in the UK where there is a UK trademark that blocks you, but the courts have not adopted that strict approach in relation to advertising and offer
you were
for
saying
sale.
that in the question of sales, the question answered itself.
On that hypothesis.
On that hypothesis, and saying, submitting that was in some way an unreasonable result, and I question that. Why, if one descends to the level of sales, why is there a problem?
Well, because one might say that if one adopts the general approach that says that passive presence ought not to result in liability, notwithstanding the fact that the website is accessible and indeed accessed in the United Kingdom by people in the United Kingdom, which is the L'Oreal approach, should there then be a rule that says, well, if there is a sale to the United Kingdom, everything is different, even if it remains a passive sale. And my lords may say, well, there's nothing wrong with that.
Passive is pretty odd language when one looks at 1, 2, 3, when there's actually a great deal of activity going on.
Well,
because Amazon is arranging the shipment, it's covering the import fees, it's arranging the exchange from pounds into dollars. There's a great deal of activity going on here. This is not passive, purely.
well,
But true it is. It comes about, absolutely, as a result of the consumer in the UK making a search. And that leads them, one way or another, to Amazon.com, and they get through to this page. So in that sense, of course, absolutely right. consumer has been pulled in. But once you get to this stage, there's pushing.
Well, my lord, I can't improve the argument by repeating it. I think
I mean, to pick up that point, the occasion on which you're asked, do you actually want to go to the UK site, is only on the first of the pages that we looked at.
Yes.
And so once you've not elected to click on that little narrow strap line, which was one of the judge's factors in paragraph
Yes.
100,
I think 68.
165, he said.
65, yes.
Yeah. So once you haven't clicked on the little narrow banner, you're then, as my lord has just put it, you're having products pushed at you. You know, the sale is then pushed.
Well, we would respectfully put it in a slightly different way, which is once you are in Macy's New York, it's true that Macy's New York is trying to sell goods to you, but it doesn't follow that Macy's New York is in fact seeking to push goods to you in London. That in our submission is the appropriate analogy in this case. So that in our submission, the mere fact that it is a natural incident of sale, that a transaction takes place which involves the vendor doing something, as it were, positive to get the goods to the customer, including making payment for those goods possible in a variety of ways, is simply a necessary incident of a passive sale being made. It doesn't make it any more active in a given territory because a particular transaction has to take place.
Right, but and I'll leave the point, but just to be clear, the judge's analysis, which is that any customer who gets to page 123 is somebody who's already decided in his mind that he's prepared to pay the extra shipping costs, etc., etc., etc. If you actually wind it backwards, the only point in time at which the customer is actually told by Amazon, you could order, well, what about going onto the amazon.co.uk website, is a customer who hasn't actually encountered any of the shipping costs, estimated import fees or anything else, because they only come late. He only finds that out later. So there's a disconnect, isn't there?
Your lordship is of course right, but one might say, well, once one finds out that the shipping costs are whatever they are, then one might say, well, I now know why I've been directed to.
Well, no, that assumes you had seen and consciously decided at the earlier stage not to follow that.
It does, and
you're not encouraged to get at this stage at page 123. There's no encouragement to say, actually, wouldn't you like to avoid having to pay all these employed fees? Yeah. I mean, it's being pushed at you.
And isn't the error that Mr. Edinburgh pointed to in the judge's judgment at paragraph 171?
I was going to come on to that.
Where at the end of that paragraph, well, it's quite difficult to understand where the judge is coming from, but at the end of 171, he says, they'll clearly have appreciated all the disadvantages of shopping in the US, but having made that decision to shop despite all those disadvantages, it seems to me to be largely irrelevant that Amazon thereafter makes the process as painless and easy as possible. Now, if that's right, you're right. But if that's wrong, he is by that language totally discounting everything he said in 165 and everything my lord is putting to you about what happens when you get to page 124 in the supplemental bundle. And he is saying those don't matter because actually there's another site that's better for you. It's not targeted specifically at you. And the question of whether the average consumer would think there was a use of the sign for making an offer for sale to the UK is a question which is not really affected by how easy the process is made by Amazon. And what I would put to you is that that is an error of law. That those were factors that were materially relevant. So imagine a different situation where at every stage of the Amazon process, Amazon says, you don't want to do this, go back to amazon.co.uk. Do you really want to do self-importation from the US? These goods are meant for US consumers. If you did that, then you might have a very strong case taking everything into account for saying you weren't targeting the UK. But because you make it so easy, because you don't remind them more than once that they could go back to co-UK, these are relevant factors. You admit they're relevant factors, and the judge has said they're largely irrelevant. And surely that's something we have to consider as to being either correct or incorrect in law.
Well, my lords, of course, have to consider it as a matter of correct or incorrect in law. I would respectfully submit that this is not, that there are 2 points. First of all, this really is part of an overall factual evaluation as to what weight is given to the entries on a given page in a sequence of pages at any given point. And the second point comes back to the point that I was seeking to make earlier, which is that if a site is not in fact otherwise targeted, if I may put it like that, at a consumer in the United Kingdom, the fact that once you have made a decision to purchase on that site, it is made relatively straightforward to do so, doesn't turn something that was not targeted into something that is targeted. And so the judge was to that extent right to say that the downstream process was not determinative, that he regarded that as largely irrelevant, whether or not the whether or not there was targeting.
Just to be very clear, the little strap line, the only thing it actually says by way of discouragement, or in fact it doesn't actually say anything by way of discouragement at all. What it actually just says, if you go to amazon.co.uk, you can get fast local delivery. It doesn't actually say, and you'd be mad to stay here because you're going to have to pay import duties and lots of shipping costs. It just says you can get it faster if you go to amazon.co.uk.
Yes. Well, my lord, I don't want to labour the point. We say that all of these factors need to be looked at as a whole. We can't look at just one of the particular items of language in isolation. One needs to look at the extent to which shipping costs would be incurred, the extent to which this would be something that would be appreciated by a consumer, and so forth. The fact that language is not sufficiently negative, if I may put it like that, with respect to a particular site is not in our submission determinative of that matter. But in any event, I think I've sought to answer my lord's questions in relation to this, and to explain why we say that this is one of those areas where there are quite difficult lines to be drawn in relation to very broadly passivity and activity in relation to commercial conduct, and that the judge seeking to do that drew the line in a reasonable place, took relevant factors into account, including the stages at which people would be considering these matters in the process. The average consumer would be considering matters in the process, and all of the other factors, and that this is not a multifactorial decision with which this court should interfere. So that's my core submission in relation to targeting and offers for sale.
Can you assist me on this? It seems to me, from your client's perspective, an important question is how far restrictions that they voluntarily implemented need to go if they don't currently go far enough. Now, if I've understood correctly, the restrictions that have been implemented cover the situation that we find at page 123, because by that stage in the process, the result of the restrictions will be you're told that you can't get these products, the products in question, in the UK. Let it be assumed that but for the restrictions 1, 2, 3 would be an infringement. The question then moves to page 116, which, as I understand it, is on any view before the restrictions bite. If it be the case that 1, 2, 3 is an infringement, I assume you would nevertheless submit that 116 is not. And what I would like to know is, upon the hypothesis that I've suggested, why you would say that that's not an infringement if 1, 2, 3 is.
Well, we would make all of the same points in relation to 116 as in relation to 1, 2, as in relation to 1, 2, 3. But we would also submit that this is a earlier stage of the process. And if my lords say, well, 1, 2, 3 is an offer for sale or an advertisement for sale, we respectfully submit that 1, 2, 3 is not. It's not targeted at the United Kingdom. It says that it will ship to the United Kingdom and that the date can be chosen, but the website there is clearly an Amazon.com website. The price is clearly denominated in dollars, which suggests that this is not an English store at all. And in our respectful submission, although it may be possible to obtain the product, it is not it's suggesting that it should be obtained in that way. So,
well, I mean, come on, Mr. Alexander. Top left-hand corner, deliver to United Kingdom. Top right-hand corner, this item ships to United Kingdom. Underneath, add to cart, deliver to United Kingdom. How much more do you need?
well, you might say, well, that in that case, any time someone who is on a website which is able to identify where they are, essentially, will be targeted on the basis that the website or the relevant information will know that it's there that they happen to be logging in from. On this hypothesis, this website would essentially be targeted everywhere, or at least this page of the website would be targeted everywhere, because as soon as you know where someone is from, then it's possible to say this can be supplied to you where you are.
Well, it's also possible to say, and it would be better for you to do it elsewhere.
Oh, indeed, and I accept that this doesn't contain, or this page doesn't contain the specific go elsewhere. You can get it more quickly, but one needs to look at this as a whole, including the dollar denomination, in order to work out whether or not this really is.
Well, you could have changed the dollars at an earlier stage.
Indeed, but if one goes back to my lord's point last night, if one thinks about, for example, the Macy's clothing example, if Macy's say, well, we will ship to the United Kingdom, or they have a list of countries to which they ship. You can go onto the Macy's website.
You love this example, Mr. Alexander, and I can see why you do. I mean, if I go to New York and I love shopping at Macy's, and I come back to England and I said, well, the choice at Macy's is wonderful and I really enjoyed it, and I hanker for my next trip to New York and I'm going to go on the Macy's website, and when I get there, it's plainly not intended for me. There's no facility to put it into pounds. There's no push, to use the expression. Then, of course, you'd be right. But this is not just for people who, again, this comes back to the average consumer. That the consumer who is going to Macy's because they went there and they like it is like the small person I described yesterday who wants shirts made in Hong Kong because they're little. So they seek out the Hong Kong shops and the Hong Kong website. Amazon is for everybody. Amazon is a universal, international, one of the FANGs, one of the global corporations addressed to everybody. The average consumer, FANGs, is Facebook, Amazon, Netflix, Google, and Alphabet or whatever. But it doesn't matter.
I'm sorry, I just hadn't heard
Amazon,
that acronym before. My ignorance.
Amazon is well, there we are. Now you're educated, Mr. Alexander. The point is that Amazon is quite different, is not comparable in any way to Macy's or to the upstate New York online supplier who some traveller knows to exist.
Well, we would respectfully disagree with that on this basis. If one thinks about the Macy's example, and I know I like it, and there is a Macy's webpage which says one can buy suits or whatever it is, denominated in dollars, and it says we ship everywhere. In particular, we ship to anywhere in the EU, anywhere in Hong Kong or whatever. Greenland. On that basis, the Macy's would, in our submission, be in exactly the same position with respect to a page on its website which had that kind of information. My Lord may say, well, this is rather more specific in that it identifies the United Kingdom, but let's suppose that you're identified wherever you are. In those circumstances, one might say, well, all that's being said is we can ship anywhere. And if the
average consumer would be in two categories. It would either be the person who, Macy's is a bad example because it's very famous, but your upstate New York, the average consumer would be somebody who'd actually been there, or somebody who got there by mistake.
Well, possibly, or had heard of Macy's fame.
No, my Lord is talking about your craft shop example.
Oh, my craft shop example. Yes.
The average consumer would not be the consumer of global international products, which is what Amazon is. This is not a bad thing. Your client is incredibly successful at it, but it can't be judged by the same standards as somebody supplying handmade tea sets in upstate New York.
No, and I don't say that it's to be judged by the same standards, but in my respectful submission, the analytical approach that should be applied to whether or not there is targeting, just to use that shorthand, should not differ depending on the nature of the undertaking.
The judge discounted, this is the thing I'm afraid that weighs with me, speaking only for myself, the judge discounted all the factors that are actually specific to the way you sell from the Amazon.com website. And he can't do that. He can't say they're largely irrelevant.
Well, I think I've made my submissions in relation to that.
We say you get my point. That's what you have to meet.
Yes. We say it's not so much that he discounted them. What he said was that they did not they did not mean that nonetheless there was targeting because they took place at a later stage, or they were not sufficiently relevant.
Anyway,
in any event,
I agree with you, Mr. Alexander. You have made the point, and it probably doesn't bear repetition. But
those are the submissions on that aspect. Can I then come on to the sales point, which has been foreshadowed? Yes, just so that my lords are clear, page 100, 116 with the restrictions in place. This, sorry, you never get to this with the BHPC products, page 116. Those restrictions actually prevent that page from being seen. You can't search in that way for those products. Now that matter was the subject of evidence and indeed findings by the judge at paragraph 67 of the judgment, and if there is doubt on that, we can perhaps bring the material along, support it, but it's 67.2, I think, of the judgment.
So how far do you get once the last...
If you search now BHPC, you don't get anything at all on this business model.
Right. And which business, remind me which business model this is?
This is the export one. Export retail.
Well, that's not what 67 says. What 67.1 says in relation to exports retail, is that it prevents BHPC brand license from being shipped outside the US. It doesn't say that, they're not displayed.
It's 67.2, my lord.
Generally, they prevent such products being sold via exports retail from appearing in search results. Right, okay. What does the word generally mean?
Well, I might need to check that, but in any event, we don't think that this page is a page that has any real probability of coming up with BHPC products.
Well, I've just
from
searched
customers
for BHPC sales on Amazon.com and I get nothing except Amazon.co.uk.
Yes. Well, that's what.
Maybe
that's
I shouldn't do my own research.
Well, we're quite content for my lord to do my lord's own research, but that is what's supposed to happen.
Yeah.
And so it's
well, that did happen.
it's good that it does.
Well, it's complicated by the fact that if you routinely buy on Amazon.co.uk, they know what your computer preferences are. Isn't that right?
Actually, I get Amazon.com in the second list. So you have to press 2, and then I get the page that has brand BHPC delivered to United Kingdom, very similar to 116.
That is
And I get that in the
MFN
second.
export.
That's export.
The manufacturer fulfilled. Sorry, merchant fulfilled.
Merchant fulfilled. Yeah. Yes, it's a load of shoes, sneakers.
My lord,
all right.
I mean, some difficulties in knowing what my lord is searching at the moment, but
To be
you know,
sure, but as you point out, MFN is different, as the judge says at paragraph 68.
yes.
And I don't think it matters for our purposes. I was airing the question because I was wondering, as I say, in terms of practical impact, in terms of how far the restrictions go. And I think the general picture emerges is that the restrictions your clients have already put in place voluntarily go a long way. Whether they go all the way that they would need to go in the event of a finding of infringement can be debated hereafter.
Yes. So unless my lords have got further questions on that aspect, can I move on to the sales aspect and the Blomqvist point?
Blomqvist, yes, indeed.
And I've already foreshadowed.
Before we get into
yes.
the detail of Blomqvist, can I ask you this question? And it's convenient to ask it right away, because of the discussion we've just been having. Now, I appreciate your client's case is that a mere sale in such circumstances is not an infringing act. That's clear. But would you dispute that to the extent that there's any requirement of targeting in this there is targeting to the relevant territory?
Well, we would submit that the answer is the same answer that your lordships should give in relation to the sales and advertisements for sale and offers for
So
offers
you
for
do
sale.
dispute that, and it
So-
comes back to the discussion we had about 10 minutes ago, where you were saying, when I was pressing you on sales, and you were saying, well, if a sale is enough, the question answers itself. So the answer to my question is straightforward. You do dispute that.
Yes, and the question for my lords is really this. On the assumption, well, there are two assumptions. One is that you find that there is targeting with respect to advertisements and offers for sale, and then there are subsequently sales pursuant to those advertisements and offers for sale. And in those circumstances, I don't think I could dispute that the subsequent sale that took place pursuant to those targeted...
If the offer for sale is targeted, then it must...
That's my first point. That's hypothesis one.
Yeah.
Hypothesis two is that the offers for sale and advertisements are not targeted at the United Kingdom. Then the crunch question really is this. Assume that the court has done a correct multifactorial analysis under that first head. And it has concluded that the offers are not targeted at the United Kingdom for whatever reasons that they may be. It may be that the court considers that the disclaimers or the directions to another website are stronger than they are here, or whatever reason. If, nonetheless, there is a sale, notwithstanding the fact that people have been told, in a sense, go elsewhere, or this is not for you, is the mere fact of sale a single unifactorial question which decides absolutely whether or not there is trademark infringement in this country?
Yeah. And so that's, in fact, the factual premise that was addressed in High Walton, albeit not in the infringement context, rather in the genuine use context, because the finding there was that, as a matter of generality, the advertisements and offers for sales on the international website were not targeted at the UK, whereas the actual sales coming into the UK were.
Yes. And the question really for this court is whether, on the assumption that it's right to take a multifactorial approach to the former, let's say the advertisements and offers for sale in the way that the courts have articulated, it is nonetheless correct to take not to take a multifactorial approach in relation to the latter, namely sales, and say that simply the fact that there has been a sale in the United Kingdom means that there has been use in the United Kingdom. Now, the Blomqvist case, it might be said, could be read as supporting the latter approach, in that, albeit in the specific context of the customs regulation, what was said there was that it doesn't matter where the sale of the relevant goods takes place, or arguably it doesn't matter where it takes place, or what has preceded the relevant sale, or even subsequent to the relevant sale. The customs regulation continues to apply to products sold to customers in the EU, providing power on the part of the customs authorities to seize and destroy the relevant product. Now, in the context of customs provision and that regulation, where you will have seen the structure of the regulation, one can see a compelling purposive reason for that result to be reached. And the reason is this. If one is thinking about customs seizure of goods that are sold into the UK, so goods that are, or the EU, not goods that are in transit through the EU, where there are special rules that my lords will have picked up from the Philips and Nokia cases. It might be said that the powers of customs authorities should extend to being able to destroy counterfeit goods, regardless of, as it were, who is liable for the acts of counterfeiting. Now,
customs regulation isn't limited to counterfeit goods. It applies to any double
No,
identity infringement.
Indeed. And I'm just going to come on to the problems. That's the first problem, in a way, with my analysis. But that's not an insuperable problem, because you might say, well, the customs regulation applies to illegitimate goods of various kinds. Counterfeit is too strong a term, but that's primarily what it's directed. The problem with the analysis is that the way in which the customs regulation is structured is to say that the powers are conferred if there is essentially infringement of the relevant mark. And so it might be said, well, if that's the case, once you've decided that infringement doesn't depend on sale of the product in the EU, or the contract either being made in the EU or title passing or anything like that in the EU, nor does it depend on any targeting in the EU, then that has a spillover consequence to the whole law of trademark infringement, which was not under consideration in the Blomqvist case, because the Blomqvist case was concerned with a rather specific issue of whether Mr. Blomqvist's fake Rolex should be crushed without him receiving any compensation. And the Court of Justice, therefore, did not, and we can turn it up, but my lords will have seen it, engage in a detailed analysis of the full tapestry or consequences of this for trademark law in general. They were looking at it in the context of the customs regulation.
I'm a bit puzzled by that submission, because the Court of Justice concentrated on the central question, which was it use in the course of trade?
Indeed.
Within the meaning of the Trademark Directive and the Trademark Regulation. And that's why, when you talk about spillover consequences for the rest of trademark law, we come back to the question I posed to you yesterday about whether we are talking about the use of a trademark and it being the same in all contexts. Because in Walton, as I've just mentioned, the context was genuine use, but the result was the same.
Yes.
So, what's the problem?
Well, my lord, we would respectfully submit that it would be anomalous if, on the one hand, with respect to advertisements and offers for sale, the law approached the matter by saying, well, we need to take a multifactorial assessment as to whether there is in fact targeting. But in relation to sales, the very fact of there being a sale having been made of any kind means that ipso facto there is to be regarded as use and, use the language, targeting in the United Kingdom. One would have a situation where for the different kinds of infringement that may be undertaken by a foreign website, on the one hand, you would have a directed targeting evaluation, and on the other hand, you would have none whatsoever. And my Lord Justice Arnold is, of course, right to say that that was, in a sense, the way in which that matter was analysed on the particular facts of Walton, because my Lord held in Walton that there was no targeting of the advertisements and offers for sale, but nonetheless the sale in question constituted use in the United Kingdom. And in our submission, if that approach is correct, then in a sense there is nothing I can say on the sale aspect, because there was a sale to customers in the United Kingdom, and there would be nothing more to add to that matter. There would therefore ipso facto be use in the United Kingdom. But the judge, in my respectful submission, did draw attention to the potentially undesirable consequences of that approach. And if I can just show my lord where he did that. The question of Blomqvist was evaluated at considerable length in paragraphs 128 to 147. And in 146, the judge identified some points made by Mr. Mellor QC, as he then was, with analogies of a customer in the UK purchasing products in the US bearing a trademark that was identical to one registered to a different owner in the UK. If they were in the US and bought those goods and brought them home, there'd be no infringement. And he said the same would apply if they asked the store to ship the goods to their address in the UK and the EU, and if the individual
which seems to be making an assumption which is not necessarily correct.
Well, my lord may say, well, that is that's the case, but we respectfully submit that it would be surprising were that to be the case, that if a undertaking in to take the Macy's example was shipping goods to a customer who had bought the goods in the United States at the customer's request into the United Kingdom, whether that would mean that there was trademark infringement in the United Kingdom simply as a result of the customer having purchased those goods, and those goods then in a sense crossing the border into the United Kingdom to the customer who was based in the United Kingdom.
Yeah, but you get, the point is you get a question there about importation, which simply isn't considered.
You're right. That's a separate question to which I will come. And then the judge goes on, if an individual rang a physical store in the US from home and brought the goods which were then shipped to the UK, EU, there would be no trademark.
Again, a very questionable assumption.
Well, my lord, we whether the assumption is questionable or not, we respectfully submit that the underlying concern that the judge expressed in that...
Well, take that example. The individual in the UK telephoning a store in the US, and by telephoning purchasing goods and arranging for them to be shipped to the UK. The judge asserts or accepts the assertion that that's not trademark infringement. But why not? And if it is trademark infringement, then the whole analysis falls down.
Well, my lord, that's right. If it is trademark infringement, but the question then is whether the law should be interpreted to make that act trademark infringement. And my lord may say, well, that's addressed by Blomqvist and other cases. But in my respectful submission, the anxiety that is expressed by the judge in relation to that matter is a justified anxiety, because what one does not want to do is provide what was described elsewhere as a long-arm jurisdiction in relation to trademark.
These are not new questions. So ever since before the birth of trademark law in this country, which we can date to 1875 for convenience, even then it was the case that travellers went to other countries and bought trademark goods and brought them home in their personal luggage, and nobody ever thought that was an infringement. But once we got on to the development of mail order businesses, then cases arose about trademark infringement as a result of mail order operations. And it was held that they were infringements, and it didn't cause the mail order commerce to break down. Why is this any different? These are actually not new questions, albeit that the internet makes them more acute.
My lord, I accept that none of these questions are really new questions. all of this is akin in some respects to mail order, and I don't mean mail order in the sense of necessarily mail order catalogues, but order by mail of from outside the jurisdiction. But in our respectful submission, the judge was entitled to raise questions in relation to that. Can I, in this context, perhaps draw my Lord's attention to L'Oreal, where the issue was also addressed, just so that my Lord knows the submissions in relation to that, because there's been a lot of focus on Blomqvist, less focus on that. And in our submission, what that highlights is that it would be somewhat anomalous were one to adopt an approach that said targeting is the touchstone of liability in the context of advertising and offers for sale, but sale is the touchstone of liability. Sale to a customer in the United Kingdom is the only requirement in relation to sale. L'Oreal, you'll find at tab 2 of the authorities bundle, and it's at page 8, paragraph 67.
You can't read page 8.
88, did I say? I'm sorry, my lord. Now, it's true that that case was primarily concerned with advertising and offers for sale. But in paragraph 67, the European Court of Justice says the answer to the 7th question is that where goods located in a third state which bear a trademark registered in the member state of the EU or community trademark have not previously been put on the market in the EEA, one are sold by an economic operator through an online marketplace without the consent of a trademark proprietor to a consumer located in the territory covered by the trademark, or are offered for sale or advertised on such a marketplace targeted at consumers located in that territory. The trademark proprietor may prevent sale, offer for sale, or advertising by virtue of the rules set out in Article 5 of that directive. And the court then goes on to say it's the task of the national courts to assess on a case-by-case basis whether relevant factors exist, on the basis of which it may be concluded that an offer for sale or an advertisement displayed on an online marketplace accessible from the territory covered by the trademark is targeted at customers in that territory. Now, one might say, well, the European Court of Justice was not there expressly saying that in relation to sales, one needed to undertake the targeting analysis.
And that question came up subsequently in Blomqvist.
Well, it came up in a particular context in Blomqvist, but in our respectful submission, it would be somewhat anomalous were it the case that one had an evaluation of targeting in relation to little 2, but you had no evaluation at all of any other factor in relation to little 1.
One has to be very careful because the context of this was the exhaustion argument, because these were L'Oreal's own goods. It's just
Yes.
that they were US goods, and then the question was whether there was exhaustion. I mean, the whole point of these questions that I refer it was all about exhaustion, because eBay was making visible offers for sale of the US products of L'Oreal. And L'Oreal was saying, well, hold on a minute, there's no exhaustion because we haven't consented to these particular ones going on the market in the EU.
Yes, and I accept that that was an important part of the context. The question, though, for this court is really whether the approach should fundamentally differ between the sales aspect and the offer for sale or advertisement. And we would respectfully submit that there isn't a principal basis for distinguishing between sales and offers for sale or advertisements. That on the one hand, one should require a multifactorial assessment and the other should not.
But it's about use of the mark.
My lord, yes.
Targeting is a gloss, as you said. And if you're using the mark, you're using the mark. I mean, you can't have a multifactorial approach to whether you're using a mark by selling a good with the mark, bang on the good, and selling it into the UK. You are using the mark in the UK.
Well, the same might be said in relation to an offer for sale, because if, for example...
Because an offer for sale is available to all sorts of people, and the question is whether multifactorially you are using the mark by advertising it to the UK when it's a US website, blah, blah, Macy's, all the examples we've had. That's a perfectly rational distinction. But a sale's a sale.
Well, my lord, on that, I think again I've made my submissions on that matter.
But I mean, L'Oreal is not really saying it's not really giving an answer. It's a rather mercurial passage.
I'm glad I'm not the only one. The way the judge analysed it, which we respectfully submit was a reasonable way to analyse it, was to consider whether or not the sale of the product took place in the EU, or whether the product was put on the market in the EU. And he sought to give reasons why there was uncertainty in relation to the ultimate disposition in the Blomqvist case. We respectfully submit that it is a reasonable line to draw, if one is drawing these lines, to say, well, if the terms and conditions of a sale make it clear that the relevant sale takes place outside the territory, that is at least a factor that should be taken into consideration in determining whether or not there is use in the relevant territory. So those are the submissions really in relation to the Blomqvist and use point. Can I come on to importation? Now, here we respectfully submit that what is attempted to be done is for the claimants to invite the court to hold that the person who has been agreed to be the importer, as between the vendor and the purchaser of the products, is not in fact the importer, and that an undertaking that is not indeed even before the court is in fact the importer. In this case they identify UPS
there's two
as the importer.
questions, aren't there? First of all, there's the question of who actually did it, and then there's the question to which you've just highlighted, which is the impact of the contractual arrangements pursuant to which it is done. Now, I appreciate you say that the contractual arrangements are key, but can we just address the antecedent question first? Do you dispute that in the example we were looking at yesterday, the party that actually did the importation was UPS?
Well, that in a sense begs a question as to what actually doing the importation means.
Physically bringing the goods into the country.
Physically bringing the goods into the country, it was UPS. But that was done pursuant to contractual arrangements. You see, you might ask the question, who physically brought the product into the country? Well, it would probably be an employee of UPS, in the sense that it was physically a person or a pilot or whatever it is. I'm not making a point about corporate relationships. My point is this, that the reason that one doesn't regard the physical person as being the importer is because there is a series of contractual relations between the actual physical person who is bringing the goods physically into the US and their employer, who is bringing the goods, who is to be treated as bringing the goods into the United Kingdom. Now, we respectfully submit that where a vendor and a purchaser agree in a relationship that is obviously not a sham relationship, to treat the importer and the person who is primarily responsible for payment of the import duties as the person actually purchasing the goods is not an unreasonable approach. If my lords would go to paragraph 184 of the judgment, the judge there sets out the terms and conditions upon which the consumer purchases the goods through the Amazon Global store. Those are terms which require the purchaser to acknowledge that those are being ordered from Amazon US, and that that's equivalent to making a purchase from the Amazon.com website, that the products have not yet been imported into the UK at the time of purchase, and that the sale takes place in the United States and is subject to the laws and regulations of the United States. It then goes on to say that there's responsibility for importation, which is that you, the customer, are responsible for lawfully importing the product into the UK.
Sure, well, none of this is in dispute. Mr. Edinburgh entirely accepts that as a matter of contract between the purchaser and Amazon, it is agreed that the purchaser is the importer. He says that's irrelevant because the actual bringing of the goods into the country is done by UPS. That's an infringing act. And the only question thereafter is who is liable for it. And the party that's liable for it is the party that makes the arrangements with UPS, as the judge found in 105, and that's Amazon.
Well, yes, but the arrangements are made pursuant to an agreement which treats the customer as the person who is importing. Now, obviously, Amazon is making the arrangements with UPS because UPS is the shipping company. It would, I expect, theoretically be possible for a customer to make their own arrangements with a shipping company in the United States to pick up the goods in the United States to bring by air or whatever to the United Kingdom. But if that were, that would be an entirely artificial way of looking at the transaction, because the customer in question here is the person who is importing the goods into the United Kingdom. It may be that as a result of the contractual relations with Amazon, they get Amazon to make the arrangements with the with UPS, but that doesn't mean that Amazon is just making the arrangements of its own initiative. It is making them because the customer is, in a sense, asking Amazon to make those arrangements.
Absolutely, and I see the force of that point. But can you help me on this? We have to make here two. We assume that the act of importation is an infringement. Obviously, if it isn't, the question doesn't arise. So that's the tort. The arrangements are made by Amazon, and so the argument is that Amazon is jointly liable for that tort because it's arranged it. So you meet that by saying, but Amazon made the arrangements pursuant to a contract with the purchaser, under which, as between Amazon and the purchaser, it's agreed that the purchaser is the importer. Why is that contractual arrangement a defence to the liability for the tort?
Well, if I make the arrangement with Amazon to say, please engage a appropriate shipper on my behalf, effectively, to bring the goods into the United Kingdom, essentially what Amazon is then doing is making the arrangements to have the goods shipped at my request as the customer. It's not Amazon making the arrangements of its own account. It's making arrangements pursuant to an agreement which treats the customer as the importer. Now, it may be that one can analyze this in terms of some quite complicated agency or sub-agency analysis. In our respectful submission, one doesn't need to get to that because the contractual terms are clear. The importer is the customer who is not liable for trademark infringement at all. And
can you point to any authority that says a contractual arrangement with a third party is a defence to joint liability for a tort?
No, I can't point to such an arrangement, but I would put the point the other way round, which is there is no authority cited the other way to say that in a circumstance of this kind, where a customer is not liable, is essentially using another undertaking as an agent to obtain the relevant goods, a customer not liable for infringement should nonetheless impose effectively liability on an intermediate physical importer and thereby impose liability on the further intermediate undertaking, namely the purchaser from which they have obtained the goods, on the basis that the vendor from whom they've obtained the goods, on the basis that that vendor is the one making the arrangements with the physical shipper. Now that situation has, in my submission, just not arisen in the cases. I don't think that's ever been suggested. And it would be very surprising because what one would then have is a situation, take this situation, UPS, who are not before this court at all, would suddenly find in a decision by the High Court or this court to have been held to be liable for trademark infringement, primarily liable for trademark infringement on the basis that they are the importer, and Amazon then liable jointly.
You don't need to have the primary party before the court in cases of joint tort fees. It happens all the time that you sue the accessory because e.g. the accessory is in the jurisdiction, whereas the primary party is out of the jurisdiction.
Indeed, but it would be, in our respectful submission, an unprecedented situation where a shipper of many goods was all of a sudden said, well, you're liable for trademark infringement, having been given no notice whatever of the fact that they were just on the point of being held liable for trademark infringement, not identified as a potential undertaking who was liable, and it then said, well, you're then going to have some apportionment of liability as between you as the shipper and Amazon as the person who is notionally the joint tortfeasor under the Sea Shepherd case.
Okay, I'm getting slightly confused here, and I'm sure it's my fault. I appreciate fully the force of the point you make about the contractual arrangements between Amazon and the purchaser, and you say that's determinative. I understand that submission. But you seem to be making a point here about potential exposure of UPS to liability, and that I don't understand. A, why is that relevant, and B, why is it a problem?
Well, one might say that it's relevant procedurally and substantively. In the case of a general shipper, for a court to say you are primarily liable for trademark infringement in circumstances where there is a contract between the person to whom the goods are shipped and the vendor of the goods, which specifically makes the purchaser the importer of the relevant goods, and provides no opportunity for them to say, well, actually, we shouldn't be liable for a whole range of reasons. Someone else is liable. in my respectful submission, that is a strong thing to say. My lord...
You say it's procedurally questionable, but I don't understand, because the decision won't be binding on UPS. If the claimants sue UPS subsequently, they'll be able to raise any defence that they choose.
Well, on this hypothesis, there would be a finding that UPS was the importer and they'd be liable for trademark infringement.
But it wouldn't be binding on them. So what's the procedural problem?
All right. Well, my lord, in my respectful submission, it would be a very odd thing to have a situation where, despite the allocation of liability under contract, both in relation to title and risk in goods and as to who ought to be regarded as the importer, for this court to say, well, I'm going to simply set that at naught and regard another undertaking as the importer and make the shipper who, make the vendor who made the arrangements with the shipper jointly liable with the shipper in relation to alleged acts of infringement, when the ultimate customer importer was not liable for trademark infringement. And now that has not been, in my submission, done before. It was a completely different situation in the Rotocrop case that had nothing to do with the
Rotocrop doesn't get anybody
it
anywhere because the point wasn't raised.
It doesn't get anywhere, that point. But that would be an unprecedented step in relation to this area of law, and it would actually, what one would then be doing is saying, okay, well, let's forget about Amazon altogether. We don't really need to bother. All we're going to do in these cases, whenever there's a sale to the United Kingdom, we're just going to sue UPS in relation to importation of the goods, even though they are people who are not regarded as the importer in these circumstances under the relevant contractual relations.
Now you seem to be making a different point, which might be important, which is that you are contesting the proposition that UPS are in fact the importers.
Yes. Yes, I am, and where there is a contract that provides that a customer is in fact an importer, in my respectful submission, it is not right to say that simply because UPS is the physical carrier of the goods, they are to be treated as the importer for this purpose.
All right, but there must be case law on what counts as importation for these purposes.
Well, the candid answer, my lord, is that we would need to look at this separately and submit a further.
Sorry, this seems to be the gravamen of your submission, and you're now saying you haven't looked to see whether there's case law or not. I mean, I know there's been a massive failure to cite relevant authority already in this case, but I mean, come on, there has to be a point in which one says,
well,
if there's case law, please draw it to our attention.
Well, but my lord, I say in partial defence of that, what we have is a clear finding on the basis of contractual terms that are agreed between the importer and the vendor, that the importer is to be regarded as the purchaser. In those circumstances, if my lord says, well, despite the fact that those terms exist, I need to show authority that the carrier is not to be regarded as the primary infringer by way of importation. I'll certainly go and look for further authority on that matter, but we respectfully submit that there is a short answer to this point.
Why is it so surprising that the contract between V and P, vendor and purchaser, shouldn't affect the question of who is the importer as against the owner of a trademark? I mean, why can two parties to a contract deprive the holder of a trademark, the registered holder of a trademark, of a claim for infringement, just by what they've agreed?
It's not a question of depriving the holder of a trademark of a claim for infringement.
Or affected in any way, in fact.
What it is saying this is the way in which these are the statuses which these parties have to this transaction.
As between vendor and purchaser.
Oh, indeed, and I have my lord's point as between vendor and purchaser. And my lord may say, well, that doesn't affect, it shouldn't affect anyone else in relation to the transaction. But we respectfully submit that once that there is a agreement of that kind, unless one can say that there's for some reason a sham in the agreement, which obviously is not said here, to treat as being the importer the actual purchaser of the goods, who then makes arrangements with a carrier to ship them to this country. That is not an unreasonable approach. It's not depriving anyone of rights that they might otherwise have.
Or indeed just affect them in any... How do you affect the status of the carrier by a contract between two different people? Is, I think what I understand is being put to you.
Well, it's not so much affecting the status of the carrier, but it is recognizing the capacity in which the carrier is acting. And this is why I say that there may be a question of agents.
Is there a difference between the word status and capacity? I'm not.
If the carrier is acting as the agent of the purchaser, albeit indirectly, should the carrier nonetheless be regarded as the importer on the basis that they are acting under the direction of someone who is regarded as the importer in the sale transaction?
Well, the principal may be liable for the agent's acts, but that doesn't stop the agent being liable.
Well, my lord, I will certainly go and see whether there is further authority in relation to this matter, if that's likely to be of assistance. My attention has been drawn to paragraph 112 of the judgment. Which is Class and Colgate. And
what the judge said at 190, where he said mere importation is not enough, there has on the basis of class.
Yes.
He says there has to be intention to put the goods on the market in the EU.
That's the point.
Do you say that's right as a matter of law? Because Mr. Edinburgh says that's flat wrong.
No, there has to be. Well, we respectfully submit that importation occurs when customs clearance has been obtained. The language may conflate two matters.
So to be clear, you accept the proposition that in the sentence bridging the pages, importation occurs when customs clearance has been obtained.
Yes.
That's what Mr. Edinburgh says. So at that point, you're at common ground.
Yes.
But what Mr. Edinburgh attacks is the last sentence, to which my lord drew attention. Mere importation is not enough. There has to be an intention to put the goods on the market in the EU. And Mr. Edinburgh says that's completely wrong and doesn't follow from the previous sentence.
No, it may not follow directly from the previous sentence, but the point is that if...
Do you say it's correct?
If one is concerned with liability for trademark infringement, there has to be a use in the course of trade. And that imports an intention to put the goods on the market in the EU.
Well, the use in the course of trade that Mr. Edinburgh was talking about was simply that UPS is a trading organisation.
I understand, and I don't dispute that aspect. As far as that goes, that's correct. But we do dispute whether or not a private undertaking bringing in goods for their own use, clearing customs, is importing in the sense required by the trademarks legislation of using the mark in the course of trade.
Speaking for myself, it seems to me that the judge didn't hear argument on this point. He doesn't mention UPS at all. he mentions he mentions importation, and he seems not to have been considering the position of the physical carrier. You get quite a number of he was considering, and he says in the issues, what I'm considering is whether Amazon is the importer. And he comes to the conclusion that all turns on the construction of Blomqvist, and because he said Blomqvist decided something, did not decide what Mr. Edinburgh said it was, the question then goes your way. But I don't think he really, apart from 190, addresses the authorities on who is the importer under the trademark legislation. And speaking only for myself, it seems to me that it's potentially quite a difficult question. And I see your submission that it would be very undesirable if UPS was the primary recipient of trademark actions simply for flying plane loads of polo shirts across the Atlantic. But we can't, I mean, I don't want to decide that without seeing what the authorities are.
My lord, that's...
And you also need to tell us whether we really need to decide that.
My lord,
it's part of this appeal.
You probably don't need to decide it, and the reason why this issue has not been dealt with in full by the judge, or one might say by us, is because we don't really detect that this was the way in which the matter was argued below. The way in which the argument was put, I'm told, is that it was said that Amazon was the importer, not UPS. And
well, that's what I've just said, yes.
Yeah, yes.
That's what the judge said.
And that Amazon should be treated as the importer. Indeed, that's one of the points that's made in the grounds of appeal.
What the judge said was, there was a contract in the US, the customer bought the goods in the US, he then, because Blomqvist is not against me, the customer imported, this is not in the course of trade, there we are, end of story.
But as far as the appeal is concerned, if you look at the appellant's skeleton argument, which is Core Bundle Tab 2, page 28 in the bundle, paragraph 42, the submission is made, it is clear that D2 and D4 were acting to a common design to ensure the importation of those branded goods into the UK/EU. The actual importer was a third-party transporter acting in the course of trade. They don't name UPS, but that's clearly who they're referring to. The acts of that transporter amount to an infringement, and as D2 and D4 were acting in common design with them to secure the acts of importation took place, D2 and D4 are jointly liable for those acts of importation. So that's the case that Mr. Edinburgh advanced in his oral submission.
Yes. Now, I understand that, and I've put forward my answers to it as far as they go in relation to the contractual relations. If there are further authorities...
Yes, but the question I'm asking you is this, and I've got two questions. First of all, the submission is clearly made in writing there that the actual importer was the transporter. Now, you're now telling us that you dispute that, and yet, apparently, without having looked at the case.
Well, if your Lordship looks at paragraph 112, where...
Well, if you're going to go to class, we'll do that in a second, but then that takes me to my second question, which is, I still didn't get an answer from you to my question about the last sentence of paragraph 190 of the judgment, where the judge says mere importation is not enough, as my lord raised earlier. And Mr. Edinburgh says that's wrong. Do you defend that or do you not?
I do defend it in this sense, that if there has to be importation in the course of trade, and the mere importation by a private individual, not in the course of their trade, is not sufficient.
Of course, but what about the importation by UPS?
Yeah, but you would say, I mean, before you get into a bit of a Barney, you would say that importation by a private consumer is not made importation in the course of trade by the fact that he uses an independent contractor who is in the course of a different trade, so as to count for trademark infringement. If it were otherwise, it would be absurd.
My lord, yes, that's another way of, in a sense, answering my Lord Justice Snowden's point. But
I'm not sure it is actually. I think it's a rather small point. But if the judge were right that there were no Blomqvist problem, and the goods were owned by the consumer in the United States, and he then contracted the consumer with a third-party carrier to bring them to the US, that is no different from putting them in his luggage and flying on British Airways.
indeed.
So that is fine, in my view, not speaking for anybody else in this court. But that's not really the problem you've got here, because you've got a much more, to use your phrase, multifactorial issue, and you've still got to deal with the question of whether Amazon was in fact making the importation and as a joint design, and if it was, then that is definitely not the same as the consumer doing it for himself, having bought the goods and put them in his suitcase.
Well, but then the question, to answer I think all my lords, I hope directly, is who is doing it for whom? If one thinks about the situation where the consumer buys the goods in Macy's and rows himself across the Atlantic, as it were, so that no one else is involved in the transaction at all. And then you can say, well, he or she is the importer of the relevant goods, paying relevant customs duties. If the person says, well, no, I'm not going to do that. What I'm going to do is engage British Airways to fly me across, which involves their employees actually physically handling the products in my luggage and so forth. In the course of their trade of luggage handling, bringing them across the customs border and so forth. Does that make them the importer in circumstances where they wouldn't be the importer in the first example?
You say no.
No. The third...
so where is the customs border?
Where is the UK customs border for these purposes?
Because if you just retrieve your suitcase from British Airways, I thought it was up to you then to take it through customs.
Yes, it is up to you to take it through customs.
So I'm not sure the British Airways example, if you're talking about your own suitcase, actually helps very much.
No,
but I do love the rowing across the Atlantic example, and I shall treasure that.
the point I'm trying to get at, my lord, is at what point does a situation arise where someone who is making arrangements with others for the bringing of goods into this country cease to be an arrangement where they are making the importation themselves and become an arrangement where someone else is to be regarded as importing those goods? And in my respectful submission, where you have a situation where they are clearly identified as the importer, they purchase goods from a vendor who then makes arrangements for the goods to come into the United Kingdom. For the purposes of the trademarks law, the person who is identified as the importer, in this case as the customer, should not cease to be the importer simply because there are intermediaries involved in actually clearing customs and bringing the goods
I get all
across the
that,
border.
but I still don't think that answers the question of the seller being involved in the arrangements.
My lord.
And I diverted you earlier, and I apologise for having stopped you. You were going to go to the passage from Class International,
Yes.
which is set out in the judgment at paragraph 112. But I want to ask you about that, because it seems to me at the moment it's against you, not in your favour. So if you look at paragraph 112 of the judgment, which is page 94 of the core bundle, paragraph 27 of the judgment in Class International, the court says that as regards whether the person concerned can consider to have himself used a sign identical trademark, although that person was acting in the economic interest of a third party, it must be observed that in order to identify use in the course of trade, ownership of the goods on which the trademark is fixed is of no relevance. So the fact that the goods are owned by a third party is no defence. Why is that not against you rather than in your favour?
Well, my submission is not that the issue of ownership is the critical touchstone here. One can.
Well, the judge seemed to think it rather was. Hence all the stuff in the judgment about where title passed.
Yes, that may be the case in relation to the Blomqvist point, but we're on a different point here, which is whether or not a particular person is to be regarded as the importer.
Well, just to be clear, at the end of that quotation, the judge does say, as is clear from 27, actual ownership of the goods in question is not necessary or even perhaps relevant for the purpose of determining
Yes.
whether the person in question is used to
But
sign
then when he comes back to it,
I am not saying that that is the critical touchstone for the purposes of this aspect of the argument. My argument is perhaps a more simple one, which is that the mere fact that there are intermediaries involved, and that one of the intermediaries is the vendor of the goods themselves, who is making arrangements with the shipper for the goods to be shipped, doesn't mean that the person actually to be regarded as importing the goods is any other than the customer.
So does that mean that Amazon, in a sense, once it has sold the goods, you say, in the US, in a sense then drops out of the picture completely for the purposes of trademark infringement, because whatever else happens, it's only ever acting as agent for somebody else, or indeed not involved at all?
Yes, I mean that doesn't help on the first two aspects of the appeal.
No.
Because on both advertising and offer for sale and sale, if there are those, and my laws find that there are those, then there would be liability. It's not a question of dropping out of the picture in that sense, or Amazon saying, well, you know, that there is no recourse in these circumstances.
I'm sort of leading up to asking you a question. We started into this by looking at the terms and conditions, which were set out in paragraph 184 of the judgment. And I was actually just curious as to the last bit of it, which nobody seems to have, which we haven't yet focused on, where Amazon extract an agreement as to what the purchaser will be doing with the product. Why does it care?
I'm afraid I can't answer that question on the fly, because that may be for a whole range of reasons. It may be that Amazon does not want to be treated as a wholesaler with people buying goods on Amazon and then reselling them in large quantities.
all kinds of reasons.
So you say it may have nothing to do with what we're just currently
hesitate
discussing.
to speculate. Yeah. It's not, in my submission, relevant to the core of this argument on importation. But can I come back to my Lord's point on class, or rather AB, being, it said, not in my favour? We respectfully say that's not right. The point of that is that a person who makes known his or her address at the place which the goods concerned to be shipped, who completes or is completed by an agent customs clearance of those goods, and who releases them for free circulation, is importing the goods within the meaning of that of the directive. Now, that is a requirement that there should be release for free circulation, that there is completion by an agent or himself, the customs clearance. And in my respectful submission, if one has the customer being the person who does that, albeit by way of agents, that person is to be regarded as the importer. And if the customer is not doing that, but in such a way that they're released for free circulation, then the customer is not importing the goods in a manner that renders them liable. Now, it might be said, just to follow my Lord Justice Snowden's point, that if a vendor not only agrees with a purchaser that the purchaser is to be the importer, but also agrees and specifically requires the vendor to say that they will not put the goods into free circulation in the United Kingdom or elsewhere, that suggests that they are even less likely to be treated as the importer. And if one then moves the analysis back to UPS, UPS is not putting the goods into free circulation. UPS is simply delivering the goods to the customer's house at the instruction of the customer. If one asks, is the post office putting my mail into free circulation in the United Kingdom by delivering mail to me from someone, it will be regarded as, in my respectful submission, a surprising result. So we submit that, just to bring the threads together, that all of these points, including the contractual terms and the circumstances of the sale and transmission of the products in question, mean that the importer should be regarded as the ultimate customer, not UPS, and that there is no basis for joint liability with Amazon, simply because it is it is a conduit for the customer to make arrangements with UPS for shipping. That's all that Amazon is doing in this connection. The customer could as easily phone UPS directly, say, please pick this up from Amazon's warehouse, wherever it is, in this case in the United States, and ship this to me in London. Does the fact that the instruction to do that is given to Amazon, which then gives an instruction to UPS, so there's an indirect instruction to UPS to deliver the goods to me in the United Kingdom, mean that Amazon should be regarded as jointly liable in circumstances where the customer themselves would not be regarded as jointly liable?
You use the expression putting into free circulation. I thought from Mr. Edinburgh's submissions that he said that when goods are in the possession of somebody who is not subject to a restriction as to what to do with them, then they are in free circulation. I mean, what if you gave the example about post office or UPS? If UPS deliver the goods to just a person, is that not the point at which they get into free circulation?
I see what my lord is getting at, and in those circumstances, it may be that the final words of that clause do have some impact, because what is then being said is you do not have the right to commercialize them further. They're not in free circulation. They are restricted. One might say that if I receive as just an ordinary citizen goods through the post, I can then sell them.
Yes.
Do whatever I like with them without any, there's no restriction imposed. And to that extent, them having come to me, they are in free circulation. If, on the other hand, I'm under a restriction that says, actually, you can't do that, that's not lawfully permissible for you to sell them.
But we know from the
private
Court
use.
of Justice's case that free circulation doesn't depend upon national law. It's an EU concept. It depends on EU law.
Yes, your lordship is right, but that doesn't mean that free circulation is.
You can't contract out of it. That was the whole point that was referred by Mr. Justice Lowdy. In the famous case, the name of which escapes me, it's so famous.
Yes, well, we would need to look at that in great detail. But in any event, my lords, I think those are the submissions that I have on the importation point, unless I can answer any other questions.
Move on, Mr.
And I then
Alexander,
move on to
quickly.
D3, and again take that from the judgment, because in our respectful submission, the approach that the court took to that matter with respect to joint liability of the third defendant was entirely justifiable.
Can you just help me? Why does it matter? I mean, in most cases in this country involving multinational companies where the parent and the relevant subsidiaries are all joined, a pragmatic decision is taken by the defendants not to raise any issue on joint liability because they're all good for the money and it makes no practical difference. So why does it matter? Why your clients are taking a stand on principle, and of course they're entitled to do that. Why does it matter?
Well, our submission really doesn't matter in this case generally for a whole host of reasons.
Because if the other defendants are liable, Amazon will pay.
Your lordship is right in relation to that, but there is a matter of principle. Your lordships may say, well, what's the point of defending on principle if one is attacked on principle and it doesn't matter? But what is being said here is that the head company in the group essentially should be liable for all of the acts of infringement of every subsidiary company in the group, at least in the United Kingdom, on the basis that it is involved in some way or another with running the business as a whole. And that is a broad proposition, and we respectfully submit that it's not adequately made out. In our submission, it might be said, well, why don't you just accept it for the purpose of this case? Because it doesn't matter.
Well, the approach that's commonly adopted, as you know, is that no issue is raised, no omission is made, but no issue is raised.
Indeed, and we, I think, are content for no issue to be raised, but I don't think that would satisfy my learned friends, because they say, oh, well,
They just want to ensure that they have all potentially liable parties before the court, so as that if for some reason there's some default, unexpectedly, then they're not tripped up by not having one party before the court, so they've joined everybody.
Yes, and if the question is, who's going to pay, or is there some defect, then I think that may be resolvable, because no one wants to have this fight just for the sake of it.
What exactly?
On the other hand, it is the claimants who have raised this issue.
Well, the claimants always have to. The claimants have to have a basis for joining people in the first place. So they name them as the parent company as defendant, and they raise the allegation of joint tortfeasorship. They have to do that because otherwise the question never arises. But then the pragmatic stance that is commonly adopted by defendants is the parent company says, we don't admit liability, but we're not going to raise any issue on it because if the claimants succeed, payment will be made.
Well, over the adjournment, I'll take instructions as to whether that's a pragmatic way of dealing with this matter. We don't want to force resolution on issues that simply don't require resolution. So can I then deal with that briefly in just really commending the decision on this respect of the judge to my lords, because we say he got it exactly right in relation to joint liability of D3. In that there was a somewhat nebulous submission made where it was said, well, the third defendant is the conductor in the orchestra, the spider in the way of the queen bee, all of these metaphors, as my lords have seen it. Paragraph 24 of the judgment. And we respectfully submit that that is not a sufficient basis for a finding of joint liability with respect to specific acts of infringement. Now, the law is obviously well established that a undertaking doesn't need to know that the acts are themselves infringing acts in order for there to be liability as a joint tortfeasor. but in my respectful submission, there does need to be a degree of specificity of involvement in the actual acts that are alleged to be tortious acts, and proper evidence in relation to that. And where one has a corporate group which has a very large range of activities, and in particular a very large range of products that are sold through that group, to say that the head company, parent company in the group should be liable is in relation to acts of subsidiaries which are specifically done by subsidiaries, where subsidiaries set up, particularly individual country websites and so forth, to direct sales in a particular way, is not correct. We particularly commend to my Lord's paragraph 205 of the judge's judgment.
Mr. Edinburgh doesn't, I think, dispute, for example, the last sentence of paragraph 205. He doesn't contend that merely being the holding company
Indeed.
is sufficient. What he points to, as I understand it, are specific instances of the parent company being involved in the advertising through the .com website, of which he says it is the intellectual property owner.
I was going to come on to those, because there are essentially two aspects that are raised. One is that it claims copyright in relevant websites, a copyright notice, and the other is in relation to data that is said to go via .com that may be used in relation to effecting the sales and so forth. I think those are the two big.
I'm not sure that
he makes.
I'm not sure Mr. Edinburgh suggests that the judge was wrong when he says you can't just make a parent company liable for everything that a subsidiary does.
Yes.
I don't. That's not what he's arguing, as far as I was aware.
So
my lord is correct.
And so, commending paragraph 205 is fine as far as it goes, because to an extent it's not controversial. What is controversial is whether there are specific instances, specific facts, which show that the parent did more than just sit there as the parent and actually got down and got its hands dirty in what's happening.
Yes. So the 2 points I think made a copyright notice, that the ownership of the relevant intellectual property in the website, and I think the other point made was the information. Personal data.
Yes.
Neither of those, in our respectful submission, are sufficient to raise a case of common design. In relation to the first point, copyright ownership, although there isn't specific evidence in relation to how copyright ownership is allocated between different companies, it is not uncommon for undertakings to have, for example, their intellectual property rights all vested in one company in a group of companies. And one can't, in my submission, read too much into the presence of a copyright notice relating to the visual layout of the relevant websites, in saying that an undertaking has specifically authorized or specifically been involved in those acts of sale. The similar point applies to personal data. Now, personal data is something that covers potentially a very wide range of...
So when you say visual layout, do you mean functionality, design of, i.e. the way it works?
Actually, any aspects potentially of the website. One of the difficulties with this kind,
such as the absence or presence of strap lines telling people that they can or can't buy certain products.
Well, it may be that the rights to that site, or the rights to that, in that case, text, are vested in one company or another in the group. And there may be implied licenses between companies in the group to, for other companies in the group to make use of the relevant design, which may be done by another undertaking in the group. There isn't evidence of that in this case, but my lord asks me a more specific question, which is, what about other potentially copyrightable aspects, the software, the underlying mechanism, I'll put it like that, of the website?
Well, on the face of it, the copyright notice would cover both the visual appearance of the website and the software, which is a copyright work, that makes the e-commerce work.
It could do, and one of the things about the copyright notice is it's not specific to any particular item on the website, whether it be the
It's a general claim to copyright in the name of the parent company.
As a general general claim to copyright, whether actually, if one did a full analysis of the law, it would turn out that it was right that the copyright was in fact vested in the parent company might be a difficult question under the law of different countries. There may be different results under the laws of different countries, but in principle,
notice gives rise to presumptions.
it may give rise to presumptions, but in our indeed, but in my respectful submission, the mere fact that there is a copyright notice in relation to a parent company doesn't make the parent company liable for all of the acts, all of the commercial acts that are undertaken by subsidiary companies with respect to the website, in respect of which there is a copyright notice.
Right. Well, I think that's a clear submission to end on.
It
Thank
is.
you, Mr. Alexander. How long have you got left?
I have about 10 minutes left, a little bit more on joint liability, just on the...
You need to come back on one or two things that have been put to you.
I may need to come back on some things that have been put to me.
No,
and
the point that you raised in answer to my lord on whether it matters, D3.
Oh, yes, I certainly need to come back to you on that. And there is a final point, which is what might be called remedies.
Yeah, you've got to come to that.
I'll cover that briefly and show my lord what happened below and the authorities to which my Lord Justice Arnold drew attention.
Thank you. And Mr. Edinburgh, do you anticipate being long in reply?
My lord, between 15 and, say, 30 minutes.
That's not long in this court. Thank you very much. 2 o'clock.